Hello, welcome to our August TSCA 30 for 30. Good afternoon, good evening, good morning, wherever you may be working from now. My name is Greg Clark. I am a partner in Keller and Heckman's Washington, D.C. office, and I'm joined today by my partner, Herb Estreicher, also in our Washington, D.C. office. Next slide, please. And we'll be talking today on two subjects. The first is the tiered data reporting approach that EPA has floated in recent weeks. And the second will be about an ongoing lawsuit on transparency in the PMN review process. Next slide, please. Thank you. So on July 14th, EPA published a Federal Register notice. And in this notice, they announced that on July 27th, they would be holding a webinar related to a proposal or a plan to create what they called a tiered data reporting scheme, which would be in support of the TSCA Section 6 review of existing chemical substances, the prioritization, risk evaluation, and risk management approach that was implemented through the Lautenberg Act amendments to TSCA. In the July 14th notice, EPA also opened a public comment period for 30 days. The Federal Register notice did not include specifics in terms of what this tiered data reporting plan would look like. There was no proposed rule language. It was clear that the webinar was where EPA would essentially unveil the curtain in terms of what they were thinking, but it did indicate some of the potential approaches and indicated that as well that as part of this tiered approach, EPA might potentially reduce CDR requirements. So as I mentioned, that webinar was held on July 27th, and the public comment period just ended at the beginning of this week. Next slide, please. So in terms of the authorities that EPA cited in the notice, less so in the webinar, but in terms of the authorities cited in the notice, so EPA has authority under Section 8 to require record keeping and the submission of reports to the agency. By and large, Section 8 is concerning existing information. The reporting standard is generally known to or reasonably ascertainable. We'll talk on another slide about what the Section 8 existing reporting obligations are and how those fit together. The other source of EPA's potential authority for creating a tiered data reporting for TSCA for existing chemicals is Section 4. So there are two areas here. EPA can require the generation of data or information for prioritization, although its authority there is limited. And it can also require companies to generate information to support risk evaluation of chemicals. In addition to that, EPA's previous test rule authority in Section 4, which was modified only slightly in the Lautenberg Act amendments, arises when a substance is determined by EPA it may present an unreasonable risk, or if it's a substance that is or will be produced in substantial quantities and is either entering or may enter the environment in substantial quantities, or it might be posing a significant exposure or to human health, to human exposure. Next slide, please. So let's step back a second here. So if EPA proposed or is opening this proposal on tiered data reporting, EPA currently collects a fair amount of data and information under TSCA. Of course, we have the CDR, which is under Section 8A. That's something that's comes around every 4 years. Of course, the next CDR reporting period will be 2024, since we just completed CDR reporting last year. That applies to manufacturers and importers of chemical substances on the TSCA inventory. And there are volume thresholds, depending on whether it's a standard chemical substance or if it's a chemical substance that's regulated under TSCA. We had the inventory reset. That was a one-time reporting in 2017, 2018, although there are ongoing requirements if a substance is an inactive substance. Section 8C, allegations of significant adverse reactions. That also includes consumer complaints. That's an ongoing requirement. 8C is in an area that's does not typically come up under TSCA. There are not many of these types of allegations reported. 8D, that relates to reporting of unpublished health and safety studies. EPA just last month added the 20 high priority substances that are undergoing risk evaluations right now, as well as 30 flame retardants to the model or framework 8D rule, and that was the subject of our TSCA 30 for 30 last month. So if you missed that, that presentation is available on our website, so please do check that out. Then of course 8E relates to substantial risk reporting. That's an ongoing requirement. And then finally section 4, as mentioned on the previous slide, EPA issued test orders for 9 high priority substances this January. And of course, there were test rules that have come out over time, primarily preceding the Lautenberg Act amendments to TSCA. Next slide, please. So this is a graphic from EPA's webinar, and it shows how EPA has conceptualized the need for data during the different stages of the prioritization, risk evaluation, risk management process. You see on the left side here, what's called the COU data set, which then flows into prioritization and then risk evaluation and risk management. So you see that EPA has grouped kind of the same type of information as necessary during risk evaluation and risk management, different information in prioritization and COU. Next slide, please. So EPA's slide on the previous page showed really three stages or 3 groupings. The first is COU. I'm going to call that pre-prioritization. EPA doesn't use that terminology, and some have suggested that EPA's proposal doesn't consider pre-prioritization, but to my mind, what EPA has described here is pre-prioritization. It's a creation of a candidate pool for the prioritization decisions. So what information would EPA need at that time? So these following slides are a bit of an amalgamation of what EPA said and what I believe would be necessary for these points based on the statutory requirements. So certainly for pre-prioritization, it's important to know whether a substance is active or inactive on the TSCA inventory. It doesn't make sense to proceed with prioritization of a substance that's inactive and not in commerce. Essentially what EPA needs for any kind of pre-prioritization would be ensuring that they have sufficient information to make the prioritization finding. Recall that under the statute, EPA has at minimum 9 months and at most 12 months to complete prioritization. And when they move to a substance into prioritization, when they essentially nominate it into the prioritization process, substance is either going to be high priority or low priority. And EPA has a very high workload. And what we saw with the 20 substances that are undergoing risk evaluations now that are high priority, that all of the candidates for high priority were in fact determined to be high priority, and all the candidates for low priority were determined to be low priority. EPA described this COU stage as essentially being CDR plus type of reporting. The information from CDR, those types of reporting requirements plus additional. And EPA seems to envision this as annual reporting under Section 8A. For prioritization, really all EPA needs is to identify a potential hazard and potential route of exposure to determine that it might present an unreasonable risk. As I mentioned, they're not going to move a lot of substances into prioritization because if they put, say, 25 substances when they only need 20 to replace the current 20 risk evaluations, EPA is going to be substantially increasing its workload. And the way that the statute is set up, that 20 substances isn't something they could drop back down to. Essentially, whenever they complete a risk evaluation, they need to designate a new substances being high priority. And so if they get to the point where they have 20 substances under 25 high priority substances under risk evaluations, they're going to be forced to continue with that higher level of workload. And EPA again envisions this one as a one-time reporting for prioritization. Next slide, please. So the two remaining stages, the risk evaluation and risk management, this is where EPA's discussed the very significant potential requirements coming into play. Risk evaluation, significantly more information is needed in order for EPA to make that determination, information on the chemical substance itself, as well as uses, industrial sectors, of course, hazard and exposure. Exposure might be determined through uses, it might be determined through monitoring data. And then, of course, things that go to risk, such as engineering controls, which obviously would reduce exposure, or PPE, and then other regulations that are in place that already control or manage risk are of course relevant during risk evaluation. EPA envisioned this as being a requirement that would come into play in the first year the substance, is undergoing risk evaluation. So essentially right after it's determined to be high priority, and that they would use 8A and 8D as their authorities here. During risk management, EPA indicated that if information changes from the risk evaluation stage, that there'd be a requirement to update EPA on that. During risk management, also, you would need information, obviously, on essential uses, available substitutes. Of course, during the risk evaluation process, making findings of unreasonable risk, EPA is not permitted by statute to take cost into account. But when you get to the risk management stage, then cost can be considered. So while that's not something that I would expect that EPA would include in a data reporting or information reporting rule, certainly cost information is critical during the risk management stage. And again, EPA foresees that being under section 8A and 8D. Next slide, please. So I mentioned that the public comment period ended earlier this week. Multiple parties requested that EPA extend the comment period, and I think they had a very good justification for requesting an extension. The Federal Register notice that EPA published that initiated the 30-day comment period was very light on detail, and EPA did not provide the slides in advance for the webinar. Those weren't released until July 27th. So at that point, we were already 2 weeks into the comment period. So very limited amount of time for the public to weigh in on what EPA proposed during the webinar. But there were some good comments that were submitted. EPA rejected the extension of the comment period, but there were some comments that did come in, and they raised some interesting questions. So I wanted to highlight a few of them. One party indicated or noted that EPA's Section 4 authority did not permit EPA to issue test rules or orders prior to initiating prioritization. So if we think about those stages that we covered on the preceding slides, pre-prioritization would not be a time for EPA to issue test orders, and that's correct in that EPA is required, if it uses its test authority under Section 4, to within 90 days after receiving any information under that, to make a determination of whether that's a high priority or a low priority substance. And so if you think about the statutory requirement that EPA complete prioritization in no less than 9 months and no greater than 12 months, well, that makes it very difficult, impossible for EPA to issue under that authority prior to prioritization, because it wouldn't have the time to do so. Now, there are the other Section 4 authorities, but there's a question of whether those would apply in this instance. Another comment was that EPA should use its 8D authority and require submission of information from new approach methodologies, bioinformatics, computational toxicology. I think that's an interesting point compared to, say, the 8D rule that just added the 20 high priority substances. Then there were some comments from NGOs suggested that EPA needs hazard and exposure data earlier than the risk evaluation stage. I think that there's some sense to that. Now, obviously, as EPA is proceeding into prioritization, EPA ought to have information on hazard exposure that's detailed, because otherwise it's a bad candidate to move into prioritization, because there is such a tight time frame to move through this process. Another comment was that all data collection should occur before prioritization. So this is arguing for a very robust pre-prioritization approach. And that included a request that EPA issue test rules and test orders before prioritization. But as I mentioned, EPA's authority under Section 4 is limited. So that doesn't seem to be a reasonable approach there. Now, EPA is continuing to update the docket, so I think we'll see some additional comments be posted that were received before the end of the comment period. Next slide, please. So I think there are a lot of outstanding questions here, because obviously EPA didn't propose specific rule language. There was a very limited amount of time in which to review the webinar, the slides, EPA's rough proposals. But, the first question I had was whether there's any additional data that's in fact necessary for the prioritization stage. Right now, there are many substances that are remaining from the TSCA work plan that still need to go through prioritization and risk evaluation, and those are preferred under the statute. EPA needs to be performing, I believe, 50% of its risk evaluations for those substances until they exhaust that pool. Indeed, the first 20 high priority substances, all of those 20 substances were on the work plan. So is it too early to be thinking about pre-prioritization and how that fits together? And is this the right approach for that? EPA indicated that its goal was in extending reporting requirements for many chemical substances to also reduce the CDR reporting requirements so that there isn't duplicative reporting. That's certainly an obligation under Section 8, but also to align those better. Of course, some of the comments that were received indicated that these NGOs not believe that EPA should reduce the CDR requirements. So whether EPA would follow through with CDR requirements, CDR reductions at the same time, to me, it seems that that should be included in the same proposed rulemaking once we get to that stage. Again, the pre-prioritization issue was a major issue when EPA was creating the procedural rules for prioritization and risk evaluation. There was a lot of concern that pre-prioritization would essentially result in product deselection. So EPA needs to be very careful in terms of how they proceed with identifying which chemicals would be subject to the COU or pre-prioritization data requirements. Processors, certainly processors are rarely targeted by TSCA rules, and certainly not by information reporting requirements, but processors are a big area where there might be data that would be useful to EPA's risk evaluations, and EPA mentions the need to include requirements for processors in its slides and as well as in that Federal Register notice. They also mentioned distributors, which was odd. EPA has very limited authority to go beyond even processors. So that was a bit confusing that they would include that there. The overarching question is, will EPA attempt to stretch its authorities under Section 8 and Section 4 in order to gather data and information for the Section 6 process? Clearly, based on the comments that have been submitted, you have multiple sides in terms of pushing EPA to use the full extent and even beyond of its authorities, and others indicating the EPA needs to dial its ambitions back. Another question is the post-risk management stage, which is mentioned in EPA's webinar. What would that look like? What sort of data reporting requirements would be required after a substance goes through risk management? I think that's a great question because One, how would EPA use that information after we've proceeded through risk management, which is at this point, you've been through the process for 5+ years in terms of gathering data. And all of these, I think, to my mind, underline the critical point for industry to continue engagement on the remaining work plan chemicals, but other substances as well. I think something that has been surprising as we've moved through the prioritization and risk evaluation process is that for many of the 20 high priority substances, there's been very limited engagement by industry on these substances. There are a number of substances where there are consortia and companies who are submitting robust information to EPA, but there are also a number of substances where there's been limited submissions. I think that's why we've seen EPA move in this direction to have tiered data reporting requirements in order to ensure that they have sufficient information. And I think that's also why we've seen test orders, because while EPA was not clear up front in terms of what, at the beginning of the risk evaluation process, what information they needed or felt that they needed, or what data gaps they felt needed to be closed in order to move forward with risk evaluation, the test orders represent EPA's attempt to gather what information they believe they need. So this all underlines the need for continued engagement for these critical substances, and specifically the work plan, because they will be the next up in the prioritization and risk evaluation process. But I think this is going to be a drawn out process and a challenging process to develop a tiered data reporting requirement. Next slide, please.
Thanks, Greg. Hi, I'm Herb Estreicher, and I'm going to switch gears a little bit from reporting to transparency. Next slide, please. So you may have noticed that the NGOs are submitting pretty extensive comments on significant new use rule proposals. And that's really a new thing. In the 35 years or so that I've been doing this, it was only up until the time of the Trump administration that the NGOs got involved at all in monitoring what's going on with new chemicals. I mean, pretty much the new chemical program was kind of a private permitting system between the PMN submitter and EPA, and really no one else really got engaged to any significant extent. That's all changing. The environmental groups are monitoring very carefully what EPA is doing with respect to new chemicals. Part of this, or their stated reason for doing this, they feel that industry is putting, larger numbers of dangerous new chemicals on the markets, and EPA is allowing that to happen. They point to some 600 PFAS chemicals that have gone through the new chemical process. And although many of them were regulated, they're somewhat agitated by the fact that so many PFAS chemicals were allowed to be placed on the market. So the environmental groups are following the PMN process very, very carefully. I want to talk a little bit about a lawsuit that was filed by the Environmental Defense Fund and other environmental groups against EPA. It's a lawsuit that was filed in the U.S. District Court for the District of Columbia. It's a Trump-era case filed in the last years of the Trump administration, but still ongoing, still pending, even though the administrations have changed. What do the NGOs allege in this case? Well, they allege that EPA operates the PMN process as a, quote, black box, end quote, that, quote, thwarts the ability of the public to be informed and to provide input as to what's going on with PMN reviews. Now, if you know something about PMN reviews, and, a lot of times I'll, look into EPA's dockets to look at the PMN, to look at the EPA engineering report, the risk assessment reports, to try to get a sense as to what was going on. Usually these documents are 100% redacted, by and large. And so, the reality is there's not a lot of information, and part of it is because of very, very legitimate confidential business information concerns, but there's not a lot of information about, what is the subject matter at take aside the question of what the actual chemical identity of the substance is. What's the subject matter of this pre-manufacturing notice? I mean, a lot of times, safety data sheets are redacted in total. Health and safety studies are redacted in total. And so the environmental groups have picked up on this, and they are alleging that EPA operates the program as a, quote, black box. They also state in their papers that they've requested hundreds of new chemicals, information on hundreds of new PMNs. And they actually list hundreds of PMNs in their complaint. And that EPA has denied their request for information about these PMNs. You may have been faced with Freedom of Information Act requests in the last year or so, last couple of years, where EPA advised you that someone had filed a Freedom of Information Act request on your PMN, and they asked you in connection with that notice to reaffirm your CBI claims. Well, my suspicion is the reason why these Freedom of Information Act requests was filed is in support of this lawsuit. Next slide, please. So what do the NGOs allege? They allege there's no transparency. They note that TSCA requires EPA to conduct its reviews of new chemicals transparently, which is true. They note that TSCA requires that EPA provide notice in the Federal Register within 5 business days of its receipt of PMN, which is true. And they also note that EPA routinely fails to meet that 5-day deadline, which is true. They allege that TSCA mandates that EPA disclose to the public health and safety studies and all other non-confidential information submitted in support of PMN. They allege that the EPA routinely withholds such information from the public, although quite frankly, more and more of that information is being put out there. It was certainly much more than it was before the environmental groups started complaining about this. And finally, they say that EPA regulations require that EPA publish the applications in an online docket, but EPA doesn't do that. Next slide, please. So what do they want the court to do? Well, they want the court to declare EPA in violation of TSCA. They want the court to order EPA to publish full and complete PMN notices. They want the court to order EPA to disclose all non-confidential business information, including health and safety studies that are submitted in connection with PMNs. They want the court to require EPA to disclose previously requested information on new chemicals that they allege EPA has refused to disclose. And they requested the court declare EPA engages in a pattern and practice of violating TSCA and to basically enjoin EPA from continuing those practices on a prospective basis and to maintain supervisory authority over EPA. So the environmentalists are asking for very, very wide-ranging relief here. Next slide. So what's going on with this lawsuit? Well, during the Trump administration, the parties in their, periodic status reports that they file with the court stated that they do not believe there's a realistic possibility of settling this case. But now, under the Biden administration, in the most recent status report, the parties announced that they've held initial discussions to evaluate the potential for settlement of some or all of the claims, are engaged in further discussions regarding the potential for settlement. So it does sound like some sort of settlement is on the horizon. Now, what's the settlement likely to look like? Well, my predictions for this is that you'll see EPA denying a lot of CBI claims that are associated with PMNs or challenging those claims. And I think you'll see EPA putting health and safety studies in their dockets of the studies that are submitted in connection with PMNs. Now, of course, the chemical identity will be redacted, but probably nothing else. And I think you'll see EPA putting PMN applications in the docket that have worker exposure, that have the environmental exposure information, that don't really contain what I think EPA would consider to be CBI. I mean, some things are clearly CBI, chemical identity, the estimated volumes, first and third year maximums, things of that nature. Maybe perhaps the specific uses, although the generic uses would not be confidential, but certainly the number of workers that are exposed, the number of hours, that kind of information, I think EPA may take the position in response to settling with the environmental groups that it's going to release that information. So we'll have to see what happens. But it seems to me the fact that EPA has signaled that they plan to settle is probably bad news. Now, where does this all go? Well, if you've been sort of watching the environmental groups, I mean, they have systematically, since the Lautenberg Act was enacted in 2016, been pushing for more and more release of CBI. As you know, they filed a lawsuit in the DC Circuit challenging the substantiation requirements for chemical identity, for maintaining chemical identity confidential, and they actually made some inroads with the court, where the court required that people justify that the chemical identity could not be reverse engineered. And as you may know, you have been required most recently to provide justification on those two types of CBI questions. I think they're going to push for more and more release of CBI information, force EPA to take a hard look at the CBI justifications. And quite frankly, in the cases where the CBI justifications are boilerplate, I think they're going to press EPA to challenge industry with respect to those CBI assertions. And so I think we're looking at an era where we'll see a push towards more and more transparency. And I think the environmental groups, emboldened by the new Biden administration, is going to make a lot of inroads in this area. Next slide, please. Well, those are my final thoughts, and we're running out of time. Next slide, please. So join us for the next Reach 3030 and TSCA 3030, which will be on October 20th. There won't be one next month in September for either the Reach 3030 or the TSCA 3030, because we're holding our annual chemical course, chemical regulatory regulations course in Washington, D.C. And we hope that you've signed up for that. And we hope we'll have it, and that the Delta variant won't make us change it to a virtual platform. But right now, we are planning to have that in September, and so for that reason, we are not having our TSCA 3030 or Reach 3030 in September. As always, we'll have our OSHA 3030 at the end of August 25th. Next slide, please. Well, so as I mentioned, the next TSCA 3030 is October 20th. There'll be a Reach 3030 as well. It's a pretty lively time. There's no shortage of topics for these 3030s. And so we certainly hope that you'll join us in October. As always, we post the presentations and recording of the program on our website. So you can find those at TSCA 30/30. And we hope that you take occasion to visit our website for that and other purposes. Next slide, please. So I'm Herbert Estreicher, and I was joined today by my partner, Greg Clark. And I want to thank you and see you in October. Take care.